Go. This is the part of the tailgate, and you can see the little flap that comes up at the back that stops things from rolling off when people are pushing stuff on or off with pallet loads, pallet movers and so forth. It's spring loaded, it's meant to go down and lock down, and then is easily released with a latch at the end where you stand on it and it pops up and you've got it. In this case it didn't work. Wait a minute. I've got to go back, Dave. I think you've gone back. Thanks, John. Yeah, that's all. That one, there's one. You can see it down. That's how you get it down, and that's how it goes up. That's what it's meant to do. Now, in this case, springs didn't work, and the bloke tried to control a heavy load on the pallet, came off the back, and it went down. And we got the job when he went. I think he sued his employer for failing to fix the springs in the thing that didn't make it work properly, and so it went. And I just choose as an example because what I've got to say today, it's more like a sermon than a talk. Forensic reports. Most of what the time we spend in this room and talk to each other is about causation. What caused it to happen? Talk for 3 minutes, I'm sure 3 seconds, and you'll understand what I've just told you about the way that thing's meant to work, why it didn't work, and surprise, surprise, we found the springs didn't work, and the boss knew about it, didn't replace them, game over pretty well. But there's more to forensic engineering, in my opinion, than just explaining the cause of a fault or a failure or an accident or an injury to somebody. And I think we could put our minds to it rather more often. Because the thing the lawyers want to know, after you've done our homework and told them why the crack's there or why the person got a crook back or why they fell, is not cause. They want to know whose fault is it, because that's where they're going. And we at Dohrmann spend most of our time chewing ourselves to bits on this question. It's called liability, and we spend a lot of time after doing the engineering assessment of the situation and the circumstances of the injury or the event or the failure, or the thing that went bang, and trying to answer that question. It's never easy. Now, it's loaded with law. When you're looking to see whose fault it is, normally there's two parties, sometimes more, that are at each other's throats, blaming each other. We don't care who we work for. The first person who rings us up gets us, defendant or plaintiff and all the rest of it. That's always thus. A lot of it is done under civil liability. Civil liability refers to what's known as the common law. It's not the law in the law books, it's just the law that develops over decades of judges making decisions about things. And we found that we need to keep up to date with what judges say and write down and publish in relation to particular cases. The second one is statutory. That's all the laws in the book. And we look to see whether they appear to have broken any. It's not our call to say they have, that's the court's business. I just mentioned contractual because that's another form of liability which I'm sure would touch some of the situations that you people find yourself in. But for every I've nearly come to the end of what I've got to say, most of it's on this particular slide. With liability, the first thing we have to descend, or anyone has to check, is what caused it, as we do well. We all do well. And I'm very quick to look for help outside our firm if we need a particular expertise. Say, I just realised with David, he was speaking tonight, I've been asked by a guy in Perth to determine whether Bunnings are right in saying we are going to sell that above ground pool, which has got sloping restraints at the side, because we think that's quite safe. Someone else says it's climbable. Is it climbable? Is it not? I think David's the man that you couldn't controvert. Well, you might say maybe you're involved in it, I don't know. But anyway, it came to my mind. We've all got expertise, and one of the benefits of being in FESA, in my mind, has been learning who is particularly good, who's a little hero in what areas. And we've all got them. So the more sharing we do, the better. The second thing we do, you've got to identify the parties. There's often more than two, and often when A sues B, B gets snaky and joins C or even D, and they're called joined. All of a sudden you've got a dog fight going on. I love working for plaintiffs when there's three dogs fighting each other on the other side, because one of them always, all they argue about is who's going to pay how much, and you don't get into trouble. But finding out who they were and what was their relationship with the person that was, in this case, hurt, that's our main bag, personal injuries. An employer's duties are not the same as an occupier. An occupier is the guy in the shop, or the person that's running the circus that you bought a ticket to go in and visit, or the cousin that you went to visit and you went into their house. They're an occupier. They have a different set of rules to an employer. The employer's obligations are set down very clearly in various acts of related to employment safety in each state and federally, and the occupier's obligations are set out in Victoria in the Wrongs Act. You need to know a little bit about that. Not hard to find. Where this one came from. It's also quite easy to look up old cases these days. AUSLIC, AUSL.com.net.
I think it's .gov.au.
So everything's on the web these days, easy to find. Then go to the fourth point, making an excursion into what codes or standards are relevant to the assessment of that the tailgate, for example. There is an Australian standard on cranes, pulleys and things, cranes and
hoists and winches.
Thank you, that's right. And I go to Hannah for that. And there's an international standard as well, and we just throw all that together with other general standards to do with what an employer should do as part of the reasoning that we would give in support of an opinion. Foreseeability of the risk. That's how likely was it that the person on the other side, or who is alleged to be the perpetrator or responsible, could have foreseen the risk. In the ultimate, it's the court's call, and you don't stick your nose into that. But you get asked anyway, so I've found clever ways of, I think they're clever, of saying, well, it's the court's, of course this is the court's business, but I couldn't help but notice that. Boom, 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 boom. So you tell them, regardless, and that's...
There's also not could have seen, but ought to have seen as well.
Ought to have seen. That's right, ought to have seen. That's right, a reasonable person in a reasonable situation, what should they have anticipated? And it's much broader than people think. Also, just where we earn our money as engineers, coming up with sensible, practical ways of mitigating the risk of getting rid of it and putting a cost on it. And courts are surprisingly generous in what they expect an employer to spend to make something right. So you're not the person, you're not the accountant who thinks that $100 worth of expenditure is excessive. They'll say, they'll laugh at that.
Yeah.
So that's part of that. I just mentioned as I go through vicarious liability. You're playing cricket at lunch and the batsman at work, and the batsman hits you in the eye with a cricket ball. The employer who's miles away is vicariously liable for the actions of his employee, and he cops that. So it gives the employer an entitlement to train, require, supervise and do things to make sure his employees don't hit you in the eye with a cricket ball. Voluntary assumption of the risk is where they come to a conclusion about cause, about whose fault it might have been, and there's a bit of handball goes on in some cases saying the other party has got some responsibility for this and should take some load, and they might get 70%, they might get 9%, they might get 20% of the damages that were awarded because they're assumed to have been a contributor to that And on that note, I'll just take you to, what's happened there, Dave?
Mate, so.
It's okay. Just to finish off, the footpath did get a mention. This is the most innocuous sort of thing. I'm told a fellow tripped where the little blue X is. It seems that he's tripped, from what I know, coming off the footpath onto a little bit of gravel crossover. There's a closer look at it here. He's gone down there and he's measured it up, and it's that deep and it's this and it's that. I told him he got Buckley's chance with that one. Number one, who do you sue? The council is the person responsible for a footpath. I can't see a thing wrong with that footpath. I haven't been there, but it looks pretty good to me. And the occupier owns that, council owns that. I can't see what's wrong with the crossover either. He's fallen at the margin. That's a tricky one. They'll each blame the other person, and you'll have an awful lot of trouble convincing anyone, people like us or in a jury, that one of them's not done the right thing by the other. And I just thought, not only because it's difficult, because it's pretty damn ordinary as well, that it was one to put to bed. And we do a lot of service to people, not only in remembering our prime duty is to the court, not to the client, always keep that very clearly in mind, but also to be able from time to time to say, we don't think much of that claim, we think it's poor. And these are the reasons. Now shut up, tell me why I'm stupid. That's all I've got to say.
Questions for Mark? Mark, you've got to take some questions.
I'll just turn that off. Yeah.